SJC-12372, Kalsoon, Ahmed-Kagzi and others, v. Shavana N. Williams, and SJC-12373, Rental Property Management Services and others, v. Loretta Hatcher.
Mr. Feldman, good morning.
Good morning, Your Honor. My name is Joel Feldman. I'm with Hugh Heisler. We're representing the tenants appellants Loretta Hatcher and Shavana Williams. After my introductory remarks, I'll be using half of my minutes allotted on the violation of LAS versus Pagan, on the issue of harm to the plaintiffs, and on trade and commerce. Mr. Heisler will be addressing whether the practices were unfair or deceptive. Part of Fred Basile's property management business is to seek the eviction of tenants in the housing court for property owners in direct violation of this court's ruling in LAS Management Services versus Pagan. His business plan has included initiating over 120 eviction cases with no legal right to recover the tenant's home, again, under the LAS doctrine of this court. Of these 120, 20 occurred during the pendency of this case.
Didn't Judge Fine say in her decision that if the property manager is an owner, that's not really a problem, but also if the property manager is the landlord, that it's not a violation of less collection management?
Judge Fine ultimately didn't rule on that, but she did indicate that if it was the lessor, that might be a different matter. That's not the case before you at this point.
So if there was a property owned by X and then there was a lessor who then subleased it, the lessor would be not an owner, but a lessor and a landlord.
That's correct, Your Honor. I think that issue has not been decided by this court.
But in any
that's
event,
correct.
he's neither a lessor nor a
That's correct.
owner.
That's correct. And in fact, there are admissions in this case that Mr. Basile brought the action in his own name on behalf of the owner and landlord.
Yeah, but the reason for my question is as you're going to get into at some point, this is not a one-time thing. This has been going on for a long time with a lot of cases in the Western Housing Court.
Correct, Your Honor.
And the plaintiffs use that for their own purposes.
Yes.
And you use it for your own purposes. And I'm just wondering if Mr. Basil in any of these other cases actually was a landlord.
The record is not entirely clear, although there's an admission that he's in the record that he's done this on behalf of other landlords and owners and understood that he was in violation of LAS versus Pagan. I also want to correct one potential misapprehension, and that is that the housing court permitted this. The housing court did not permit this. That is, whenever this was raised, the case was dismissed or other action was taken to say this is unlawful under LAS versus Pagan.
Is that right? Do we know that from the record?
We know that from Judge Fine's opinion, absolutely.
I don't know.
She said that the court did, I'm sorry, Your Honor.
Go ahead. No.
She said the court did not tolerate this, and that when this was unearthed and ferreted out to her, that the court did take action.
Those are two different things. I think she said that they rely on the adversarial process to ferret this out.
Right, but I think as Judge Gant said here, the issue is how is the housing court otherwise supposed to know whether the person might be a lessor? So in other words, I understand why it needs to be raised in order for the housing court to take action, unless there was some other system or rule in place to say, if you're going to come in and do what Mr. Basile's doing, you need to somehow certify what you are so that the court would know that in advance.
Although the housing court's form sort of confuses the issue, doesn't it? The form, he answers the form honestly, because the form has a three-part thing: plaintiff, landlord, leaser, right, or something. And plaintiff, landlord.
I think it's owner, plaintiff, landlord.
Plaintiff,
owner.
landlord, and he's one of the three.
Well, certainly he's a plaintiff, Your Honor, and that's
Right.
that's true. As many people, for example, in abusive process cases, there's always a plaintiff also. Whether
This could be clarified in the housing court by saying, by clarifying the form, couldn't it?
Sure, I think that part could, and then Mr. Basile wouldn't have been permitted to bring any of these cases, is the point. That is, 11 years ago, this court said that what he's doing is illegal, and to be clear, that he has no rights to ask what he's at, and he has no rights in the case, is the exact wording of this court in LAS versus Pagan. That is, when you're a property owner, manager, excuse me, and you're not the owner or lessor, you have no rights in the case to bring an eviction action. You may not recover possession from a tenant. And I guess the last admission I want to say is that Mr. Basile has said he knows he's doing this in violation of LAS versus Pagan.
And what is your understanding of what the housing court, because the housing court clerks, he's a familiar player there, right?
I can't speak for the clerks, but he's
Well,
there.
but-
He's certainly been there over 100 times. That's correct, Your Honor.
Right, and there's, I mean, the admission that you rely on has a qualification that basically the housing court, the clerks, and I can't remember the third group, all knew who he was and what he was doing, and basically it was a way of basically managing, you know, an environment where everyone is pro se and no one knows the rules.
Well, I think that that's not exactly true, Your Honor.
I'm oversimplifying, but I think that's the defense, is that he's a matter of convenience there and tolerated.
Well, I think like any other case where this court looks at it and says, just because everyone's doing it doesn't mean it's not unlawful.
I'm not saying it's right, but I'm saying that it seems like you're saying a 93A violation, and he's being upfront with what he's doing in a certain way.
Well, I
It's
think what
not
he's being upfront about, Your Honor, is that I'm upfront that I'm doing something illegal over and over and over. That is, he admits he's violating this case doctrine that's incredibly clear from this court. And I
Well,
think,
I think it's incredibly clear if he prosecutes the case. Whether he can show up at a conference or not for informal case resolution, I don't know the answer to that.
well, I think there are some permissible options. That is, he certainly can be a witness if he's involved in repairing property and he needs to testify about that. And there are some circumstances where it's permissible not to be an attorney. That is, you clearly can't commence a piece of litigation on your own for someone else if you're not an attorney. And that's the case before this court. But I do agree there may be some other instances where he's allowed to be in the court and be part of a case, just not in this manner.
Well, the appellees, they're not conceding that Mr. Basile in this case was practicing law. When they look at in re shoe and they look at it a case-by-case basis, you've got an independent counterclaim for practicing law, and that's the gravamen of the 93A claim, and they are in no way conceding that in re shoe, that standard constitutes practice of law here.
But what they have to concede, Your Honor, is that there was an injunction from this court saying you are violating LAS versus Pagan. You may not ever do it again. That's unappealed. So whatever they want to call it, unauthorized practice law or something else, it's undisputed that they violated LAS versus Pagan because there's an injunction currently in place, which is unappealed. I just want to, my time is short on my part.
So why did the judge not order a 93A violation then? If it's so obvious that this is in clear violation of SJC precedent, why did she not find it a 93A violation?
Well, with all due respect to the housing court, I think she just used the wrong framework. That is, she did not look at this case and use the traditional 93A analysis. Is it unfair? Is it deceptive? The other pieces that one uses when one evaluates it. Our position is that she used the wrong framework and looked at some kind of unfairness to Mr. Basile, which really would be unprecedented in this court's
Of course, maybe she used the wrong framework relative to the injunction, and there really wasn't a determination of the likelihood of success on the merits, but she wanted to make sure that Mr. Basile wasn't doing this anymore because of LAS.
Right, but that would go to your point, Your Honor, about that they're disputing that they did something illegal under LAS versus Pagan, and she found clearly they were. She didn't. She didn't explain her decision very well.
But is it illegal enough for the counterclaims? Because the counterclaims, tell me if I don't have this, I'm maybe oversimplifying. The counterclaims are assuming that there is an independent cause of action here for a counterclaim for the unauthorized practice of law, and that the 93A claim is the unauthorized practice of law. So
Well,
if she didn't find that,
Well, there's two pieces to it. Again, she really didn't analyze it in any way that one would look. In other words, she didn't say, is this unfair? Is this deceptive? Was there harm, et cetera? She just made a determination that it would be unfair to Mr. Basile to find that it was an unfair and deceptive practice under the UDAP statute. So in terms of the statutory sort of analysis, it's really unclear what happened. with regard to that, to the decision.
Putting aside the unauthorized practice of law, is it unfair and deceptive practice to file a complaint as an owner or a lessor when you're not an owner or a lessor?
Yes, that's what this court said in Elias versus Pagan, Your Honor. That is, the facts were exactly the same. There was an initiation of a lawsuit by the property manager on behalf of an unnamed owner. There was an
In LAS, I forget, what was the name of the plaintiff?
It was LAS Management Company, care of the name of the owner.
At least there they had the care of the owner.
So you could at least identify, I
Here
mean, there
there's not the-
arguably was better.
Here there's not the care of the owner. Here
Right,
there's no
so here
reference to the owner.
You had an unnamed owner, and you had no idea, in fact, who the real quote-unquote party in interest was who could have brought an eviction and could have recovered possession. But to go to your point, Your Honor, there was a complaint, there was an answer and counterclaims, and then there was a dispositive motion. And this court said you should have dismissed the case because this property manager, there were 2 points, has no rights in the case. And therefore, the only thing they're doing is representing the owner who would have rights in the case, and that's why it was the unauthorized practice of law.
All right, thank you.
Thank you.
Mr. Heisler, good morning.
Good morning. My role in this tag team approach to oral argument is to address the ways in which Mr. Basile's conduct was both unfair and deceptive in violation of Chapter 93A.
Are you also going to talk about how your client was harmed in that discussion?
Yes, Your Honor, and I think it's very important to recognize that these 2 cases are very much distinguishable from the Hirschenau line of cases. In those cases, there was arguably unfair and deceptive practices by the other party. However, there was no discernible or obvious adverse impact on the parties raising the 93A claim. This case is very much different from that. Our clients, along with the dozens of other tenants who were hailed into court by Mr. Basile, they had a lawsuit filed against them. They had to go out and find counsel
If the landlord had brought the lawsuit, obviously it's all completely fine, right? The big problem is that it was brought by Mr. Basile, right?
That's correct.
So everything, if they'd done this through a landlord, or even if they had done it, if the landlord had done it himself or herself, or they hired a lawyer, this is all fine. So the harm is that they did it through Mr. Basile, which actually ends up helping your client, ironically, because he can't do anything. So in certain ways, even you've benefited from this as well as been harmed from it.
I think clearly that's not the case, Your Honor.
Really? I mean, if
think
they'd
it's
done
not
it properly, they could have removed you, but because they did it improperly, they couldn't have.
I don't think whether someone could have or would have brought these cases legitimately against our clients has any bearing on the analysis that this court needs to pursue in looking at whether Mr. Basile's conduct was unfair and deceptive in violation of 93A. It would be entirely speculative, in fact, to look at whether or not a lawyer or someone else could have brought these cases. In fact, there's a very good chance, given the posture of these cases, that if the owner had gone to a lawyer instead of Mr. Basile, and it's important to note that Mr. Basile was representing the owner. If they'd gone to a lawyer might
Instead of the owner, instead of hiring a lawyer who's expensive, hires Mr. Basile's company to do this. I understand it, and I can see why it's illegal. The harm is that someone cheaper was able to do this, unlicensed, I get, you know.
But there's much further and deeper harm than that in this case, particularly given the fact that Mr. Basile brings these cases in the name of his unincorporated unincorporated business on behalf of an unnamed owner. By doing that, he effectively not only insulates the owners from claims that tenants are entitled to bring under the Hemingway case, entitled to bring in eviction cases, but he obstructs the ability of the tenants to effectively defend themselves. Because under the rubric, under the summary process rubric, tenants who prevail on particular counterclaims in cases brought for non-payment of rent, as these two cases were, can effectively defend against those cases if they prevail on counterclaims that they have asserted against the owner. In this case, you have an unincorporated, particularly with respect to my client, Ms. Williams. She is an exemplar of the adverse effect of Mr. Basile's business practices because she had no relationship with Mr. Basile, didn't know who he was, had no counterclaims that she could assert against Mr. Basile, but had very, very powerful counterclaims that she could assert against the owner. You have an unsophisticated, unrepresented, the vast majority of tenants in housing court are unrepresented. The court can simply not expect unsophisticated, unrepresented tenants to have the wherewithal to join the proper party, bring a motion to join the proper party.
Well, let's let's slow down and do this record for a moment, okay?
Yes.
I know we've had you skip over a couple of things to get to cause. Unfair or deceptive, and you're going to talk about why it's unfair or deceptive, but we've been focusing on harm. And going to the point that Justice Kafka, I think, is getting at about the harm, we're limited to this record. This is not about 109 other cases. It's about these two cases. And whether or not you're able to show harm, I think you have an argument that you don't need to show harm, but if we think otherwise, the harm, I think in the briefs, might be there, but there's no affidavit that's part of the summary judgment in the housing court. So how do we look at whether or not there's harm under 93A if harm is required?
Well, this court has been very clear that being hailed into court and having to unnecessarily litigate and engage in unnecessary litigation constitutes harm. And there's no question in this case that our clients were brought into court by someone, hailed into court by someone who had absolutely no right to bring the case in the first place.
I'm having a hard time, though, with that, because if it wasn't Basile, it would have been either the landlord or it would have been a lawyer.
Could have been.
So where's the harm?
Well,
What happened anyway?
The harm is based on what Mr. Basile, his own conduct. And I think that's the analysis that's appropriate in these types of cases, is that he was not the owner. He was not the owner. He was not the lessor. He brings eviction case against our clients, naming his company who has no right to bring the case, seeking relief that he has absolutely no right to obtain. He's seeking possession, and the court was very clear in LAS that a property manager has absolutely no interest in the property.
Can I ask a somewhat esoteric question related to that? We've got terrible problems getting representation in this area. Are you saying, and I mean, a paralegal couldn't do this. I'm just trying to understand the rule you're setting up here, which is it needs to be the owner or the leaser or whatever. No one but a lawyer or the owner or leaser can do this. I'm just trying to make sure I understand the rule, because I think there's a practical problem out there, one that you don't like, but there's on your side too, which is that the people you care about can't always get lawyers. And I'm just trying to figure out, are we going to be banning all of them from getting any kind of non-legal assistance too?
There is very definitely a role for non-attorneys in enhancing access to justice. And there are programs that have
But
been...
access to justice is a two-way street, and I'm just trying to understand what we're doing here, because I get what you're saying, and I see the clear statutory basis for it, but he is doing on the other side what you seem to support on your side, which is paralegals, other licensed people helping, because it's cheaper, and he clearly understands the rules of the game, but we're banning all of that.
He's absolutely not the same as other efforts to bring assistance to unrepresented litigants, whether they be tenants or landlords. In most of the types of programs that you're referring to, they have been thoughtfully developed under the supervision of attorneys, where there's oversight and there's monitoring, and they've been put into place to assure that they actually function within the confines of what the law requires. That is simply not the case with the way that Mr. Basile conducts his business.
If I can go back, the owner, of course, even though you've won, can now sue, can now bring this claim again and bring your client back to court, correct?
If the owner, certainly this court acknowledged in LAS that the real parties in interest can represent themselves, assuming they're not corporations.
I mean, in terms of the issue of harm, your client had to go to court to defend against this matter. She wins. Now they can bring her back to court and do it again and do it right.
Yes, they could, assuming they do it legally.
Right. So if she wins, she has to come back again to actually fight the real owner.
Certainly, if someone is brought into court legally by someone who has the legal right to bring them there, then we would not argue that they were harmed by having to respond when they have been lawfully brought into court.
I'll give you've been hijacked to discuss the issue of harm when you were there to discuss the issue of unfair and deceptive practices. So I'll give you 2 minutes to be giving us your discussion of that, and then we'll.
Well, maybe in that short period of time, I will focus in on the ways in which, and I think I've addressed to some extent the unfairness of Mr. Basile's practices. But in terms of the deceptiveness of the practice, Mr. Basile presents himself, and I would respond to an issue that was raised by Justice Kafker earlier, that the housing court recognized that they had no independent method of ferreting out when someone is engaging in the unauthorized practice of law. I don't think it's the impact on the court or court personnel and how they manage cases that's important. It's the impact that this behavior has on tenants, the vast majority of which are unrepresented. And they don't know. Court personnel might, we might, but they don't know that Mr. Basile is not a lawyer, that he does not have the power and the authority to bring an eviction case against him. They don't know that he has absolutely no right to the relief of possession that he is seeking in the case. And with respect to deceptiveness, it's conduct that has the tendency to deceive. And here Mr. Basile presents himself as someone who has the power and the authority to bring an eviction case when he does not. He presents himself as someone who has the right to possession of the property when he does not. He knows that what he has admitted, there are admissions in this case, that he knows that what he is doing is wrong. And the tenants do not.
But it's unfair and deceptive, right? So you said before that the tenant might have counterclaims against the landlord, but doesn't have the counterclaims against Mr. Basile. But if they assume that this is some lawyer, they know who they are and they know what their situation is, how is it unfair that this guy is bringing the suit as opposed to the actual landlord or the actual owner?
Well, partly for the reason that you mentioned and that I previously mentioned is that, particularly in Ms. Williams' case, she didn't have any counterclaims against Mr. Basile. She didn't have any. She was unable to, or she could not have asserted counterclaims directly against Mr. Basile, absent the 93A claim that we asserted for unauthorized practice of law. But if she was unrepresented as a legal matter, she would have been blocked from asserting those counterclaims and successfully defending the case unless she brought the real party and interest into the case.
Why couldn't she? I mean, if it were some total stranger who wasn't an agent of the landlord, bring suit to kick her out of the house, I assume she can bring all kinds of actions against that person. If some person with no connection to the landlord tries to kick her out of her home through the legal process, she can't bring counterclaims. I would assume she's got a ton of different actions against an imposter.
And one of those actions should be under Chapter 93A. The purpose of Chapter 93A is part of the purpose, and part of the purpose of the multiple damages is the deterrent value and the deterrent effect that the risk of being exposed to those damages has on the conduct of parties. And as has been pointed out by the court and others in this case, the unauthorized practice of law in the housing court is rampant. And while there may be conveniences to the housing court in having people engaging in the unauthorized practice of law, so far.
When you say that, when you say that it's rampant, is it rampant on both sides? Meaning that you've got tenants coming in with people. I mean, for example, you don't speak English, and you've got somebody, your friend who speaks English representing you. I mean, do we have this on both sides? I'm just trying to understand sort of how it's working out there, because you may end up preventing all of the other side of this too. When you say rampant, do you mean on both sides?
No, I don't.
Okay, so it's just their side who's having people who aren't lawyers representing somebody?
There are certainly programs that have been established with the approval, with the review and approval of the court system, including this court, and other programs being promoted through the Access to Justice Commission, but they are operating within the confines of the law.
Are they consistent with LNF?
Yes. They, to the extent that there are paralegals and non-attorneys assisting tenants and giving them information and helping them prepare pro se pleadings, they are doing it under the supervision of attorneys in a manner that has been, reviewed and has been approved by the courts.
Well, I think what Justice Kaff was talking about is you go into the into the summary process session in the district court on the Thursday morning, and the tenant's adult son is helping the tenant through the process, and it's pretty hard not to see that on a Thursday morning in a busy district court. So I think that's what he might be referring to.
I would suggest that that's dramatically different than what is what is being represented to the court in this case, where you have a non-lawyer who is actually bringing a lawsuit against a party who is a non-attorney, and, as he has admitted, litigating those cases through to conclusion unless
I don't think he's
stopped.
admitting that. He's admitting a narrower. He's saying he's helping bring things to conclusion. He's not saying I'm litigating them to conclusion.
Yeah,
All right, well, we'll find out what he admits to. Thank you.
thank you.
Mr. Comack, we appreciate your patience. We'll give you equal time if need be.
I'd appreciate that, too. I have a lot to say, Your Honors. First of all, my name's Stanley Comack. I'm here to represent Fred Basile, doing business rental property services. My opening statement is that his actions in these two cases, specifically in the Western Division Housing Court in Springfield, do not constitute conduct in violation of 93A. I'm just going to give you a quick overview, and then I'm going to go in depth as much as I can on each area. Number one, I want to make it very clear, even though it's stated by my brother attorneys, we're not here to overturn LAS. There were unanswered questions, which we will talk about in a moment. Number one, there's no facts.
You admit that your client is in violation of LAS.
I do not admit that he's in violation of the decision that you made in LAS. Your
You're
Honor.
saying that your client's conduct is consistent with LAS?
I'm not, that's one of, his conduct is one of the unanswered questions that you've had in LAS, this court had in LAS.
Which part of it is unanswered?
Okay. I'll address LAS, Your Honor, stood for proposition first from the lower bar that the commencement prosecution and the advocacy before the court, okay? What was stated here by Justice Keever, Ms. Basile has never litigated anything. In LAS, it was clearly stated, they filed a complaint for injunctive relief, signed a complaint as agent for the owner, managed the prosecution of a complaint and cross-examined witnesses. That is not what Mr. Basile did. He filed and signed a complaint, and then through the process, he might have done mediation and done agreement, okay? But that's not, you said those things, as those things occurred, because it's only for the bar, for the commencement prosecution and advocacy, that those specific facts in LAS.
But isn't filing and signing a complaint, isn't that in and of itself the violation of that case? Because
I would take the position that you did not, the court, Your Honors, did not say that. You did not say that. That was for the fact pattern here, that we have a fact pattern in this case. You did not say that in LAS. You did not say, you said all those things combined are the unauthorized practice of law. It's clear then in your
why would you be
conclusion.
able to file and sign the complaint if you're not a lawyer and you're not a landlord? Why would you be able to do that consistent with the statute?
That is what Judge Fine is saying, that it was a violation of LAS. But even if it was a violation of LAS, Your Honor, it doesn't rise to a 93A claim.
That's a separate
Okay.
question, yeah.
Yeah, but it may violate a couple of the prongs, but not all the prongs that you stated in LAS. You even stated.
But the statute, doesn't the statute require you to do the eviction? Don't you have to be the landlord or the owner pursuant to that statute?
No,
You
it
don't.
says a person.
Person.
239.1 says person bring forward. I don't believe it says what you're stating. I don't believe so.
So if you owned an apartment, I could bring a summary process action against you seeking to remove you because I'm a person?
I'm just saying LAS didn't clarify, just by the mere fact of signing and filing the complaint, that it was the unauthorized practice of law. That's the only statement I'm making.
But in LAS, the person signed it on behalf of the owner. Your client signed it on behalf of its rental management company.
I'm saying what may come out of today is that it would, this court will consider it the unauthorized practice of law, but it does not then become a 93 violation, okay? You specifically stated what happened in the conclusion of LAS, okay? You vacated the judgment, it was dismissed, which has been the only remedy available that on all the cases cited, they have no precedent for anything else but dismissal.
Well, no, it didn't do that. It dismissed and it remanded the counterclaim for the unauthorized practice of law.
It's for the consideration
Right.
of that
So it didn't
counterclaim.
just dismiss.
And then what happened, if you follow that through, we went back to the housing court, and the case eventually got dismissed because there was discovery sanctions, and the case was dismissed. What happened is that the landlord, the tenant attorney, did not go to a discovery session. They brought a motion of sanctions to strike the counterclaims, which was allowed. He felt he didn't have to go because he was ready to stipulate there were no damages under 93A because the plaintiff had found another apartment for the tenant.
But I'm more concerned with Justice Ireland's opinion and what the SJC did in LAS, which, as I understand it, they sent it back to the district court for consideration of the counterclaim for unauthorized practice of law. What do we read into that part of the decision?
That 93A should stand as a separate statute. You have, if you've been injured, and you can seek damages under 93A. It can't be a per se violation. You stated that in Claremont, okay? That if not every violation of the building code is a 93A violation. You say that, otherwise that would make it the preeminent law of the Commonwealth. And that's what they're trying to do that. They're trying to make this as a penalty over and above dismissal of a case, okay, that it's a per se a 93A violation. That's not true. It can't be.
I'm a little bit confused, and there may be an answer somewhere in the case law that I missed, but can you give me an example of somebody who would be a landlord who could bring a lawsuit but who would not be a property owner?
Yeah. I'm not aware of a case on that. Judge Fine, in her decision, is saying that, in looking prospectively, that unless you're the owner or a landlord lessor on the rental agreement or a lease.
So if the property management company, Mr. Basile, had been on the lease, would he then be permitted to bring a
Yes.
lawsuit?
Yes, in the Western Division Housing Court.
Without having to be an attorney? Okay.
Yes. That is part of her decision, because in order to be a landlord, you don't have to be an owner, okay?
Right.
A manager in his capacity, okay, in his role as capacity, okay, can be the landlord, okay, and have the right to bring summary process if the owner gives him authority to assume control of the property. He rents out the apartments to the tenants, and he's listed as a lessor or landlord or on it. And but most importantly, that he assumes the responsibilities and liabilities for the care of the property.
Okay,
And in that capacity, the manager is considered the landlord.
But
and
is
should
your
be able to move
record,
forward.
your record doesn't suggest you're in that category, right? You're,
Not in that category.
I mean, I'm just trying to understand why Judge Fine finds you're not allowed to do what you did, basically bring this complaint. She finds essentially that it's unauthorized practice of law, I guess. You're not upfront about who you are, in the sense that you don't say you're an agent for the landlord. It appears that it could be unfair and deceptive.
Okay, I think it's important, and I'd like.
But can I just, let me
Sorry,
load the
Your
question, one
Yeah.
last thing. It seems like she's not finding a 93A violation because the court has tolerated this. Am I misreading what she's doing? That because of the just terrible burden in the housing court with all the pro se's, that this provides some sort of structure. It's not appropriate, but we haven't shut it down yet, so it's not right to hold your client into a 93A violation. Because it's deceptive in the sense he's not a lawyer or the landlord. He hasn't said it. It's unfair for the reasons your brother says, which is, you know, they're being brought into court by someone they don't know who it is. I just don't know why it's not a 93A violation. I'd just like to understand your perspective.
I'm going to tell you why, Your Honor, or Your Honors, okay? You must understand a typical day, a Thursday, in the Western Division Housing Court.
I'm sure it's a zoo.
Okay, there's between 100 and 200 cases every Thursday in the Western Division Housing Court. When the judge first comes out, he gives a speech with regards to mediation. With regards to what's really important, in the jury room, which is on the same floor, is legal services, Lawyer for the Day, Mass Mutual, all giving help to tenants. He explains mediation, explains agreements, okay, that if you don't understand it, don't sign it, okay? And there's all this legal help that's available, and they're funneled over to see them. There's no help for landlord. Okay, then you go to the next process.
But most of the landlords are either there by themselves or represented by lawyers, right?
Correct. For the most part, there's no help for landlords.
So are you saying that you should be treated like the access to justice people in the sense that you're providing this type of service to landlords? Is that what you're saying, and that's why it's not a 93A? I'm just trying to understand where you're going.
Where I'm going with this, Your Honor, is that the process then begins that the sitting clerk asks if you want to, the people want to talk, you want to mediate, you go to trial. And even if you want to talk, you want a mediator present. Mediation is available. But here's the key point why it's not, Your Honor. The course procedure, getting back to another point you made, since LAS has been, okay, if the issue is raised by the other side, they will give the plaintiff 1 week to obtain counsel. And that's been the procedure of the court since LAS. But what clearly you need to know, and the procedure of the court, that every agreement made with landlord and tenants must be reviewed by a court official. There's 2 judges, 3 magistrates, 5 mediators. We have a court where there's 5 mediators available. Every agreement has to be approved by a court official to make sure that it's reviewed in its entirety, that the tenants know what they're signing on for, and they can live up to their responsibilities. And that's why it's not an unfair and deceptive act, Your Honor.
And does Mr. Basile say, Your Honor, you should know that rental property management is not the owner or the landlord of the property?
As Judge Fine said, she lets the adversary process ferret that out. And what you have...
Try my question. You say that the judge approves it. Is the judge informed that rental property management services is not the owner or the landlord of the property?
That question isn't asked to Mr. Basile or anybody else, Your Honor.
So how is anybody supposed to know when the judge approves it that your rental property management services has no right to be seeking possession of a property that it never had possession of?
They don't. They don't know that, but that's what the judge is trying to ferret out, that the adversarial process, if there's attorneys, they have, as legal services automatically says that they must have an attorney.
Okay, but 95% of tenants don't have lawyers.
And 50% of landlords don't have lawyers.
Or like 20%, but in any event. But, okay, I understand that there are unrepresented tenants, and unrepresented landlords, but I don't quite get your point as to why that changes the ability of a landlord to bring a case in a different name than the owner of the property.
We are just trying to say that this has been the practice of the Western Division Housing Court. This has been the practice of the Western Division Housing Court. and Mr. Basile shouldn't be held responsible.
But I'm
193.
going back to my earlier point. Are you saying then that if you were to go to trial in a matter, let's assume the tenant wishes to go to trial, you were saying that the judge would grant summary process to rental property management services knowing that it's neither the owner or the landlord?
But that, if it went to trial, as you know, there's discovery and different methods to determine if he's the owner or not. So that could have been determined through the process, Your Honor.
But it's not.
You're asking if it went to trial.
Yeah, but I mean, you weren't the owner or the landlord. You had no entitlement to possession of the property, correct?
Correct.
So how can you bring an action for possession
Yeah,
of the property when you don't have possession of the property?
Again, I'm not disagreeing that it may be the unauthorized practice of law. I'm saying it doesn't rise to a 93A violation. Then I would like to quickly comment, okay?
We'll give you more time because we gave them more time.
Okay. You have the three prongs in order to get to a 93A claim. There was an unfair and deceptive act within trade or commerce, and it has to be some harm, some damage, okay? And the Claremont case talks about in order to be a violation of 93A, okay, it must be the conduct leading up to the violation must be unfair and deceptive. The conduct leading to the up to the violation. In Tyler versus Michael Stewart, it was that in order to recover, besides the violation, you must have some separate identifiable harm that was caused by that violation.
They're saying being dragged into court by someone who's not a lawyer and not the landlord or the owner is a harm because they have to either leave their place of work to defend themselves or hire a lawyer. And that seems like we're not dealing with Liardi type of esoteric harm. That sounds like real harm, doesn't it?
I don't believe it is, sir. I don't believe, Your Honor, that is real harm. It's theoretical. In reality,
If my neighbor brought me into court to try to get my house, that's got to be harm to me, right? I mean, I have to go and leave the bench and go defend myself and get a lawyer. That's got to be harm, isn't it? I mean, that's harming us. I mean, whether it's justified, that's a whole separate matter, but that's decided in a different case when the right person brings it, right?
it's harm that has to be proved. They went based upon a summary judgment motion that they agreed to have judgment. In all the other cases that we dealt with, it's been a factual part of the record.
But you've admitted you're not the lawyer, you're not the owner, and your client admitted I think he knew what the standard was from LNF or whatever the case, LAS. So I'm just not sure what more they have to do except for, it seems like your defense is, it's so chaotic and no one has the resources that we're allowing non-lawyers to help make this work. And that may be what Justice Fine is doing there, but I'm just trying to understand if there's something different than that makes it not a 93A. But it seems to me it's just the chaos and the enormous load everyone has out there that justified allowing your client to do this for a while.
The practices of the court have to be taken in consideration. This has been going on for 11 years in the Western Division Housing Court. It's been relied on by Mr. Basile and everybody else. He's not the only person in this situation. I would like to get back to damages for a moment. So if it's the unauthorized practices of law, it's subject to dismissal, okay? If they want anything else, a penalty or what they want to be, have a penalty as a pro se violation, okay? What happened in this particular case with Mr.
But isn't it also not only the unlawful practice of law, it's the unlawful practice of property management too, isn't it? I mean, your client isn't being sued for being a bad lawyer. Your client is exceeding his authority as a property manager, right?
But as you stated, there's claims, you can bring counterclaims and seek damages for those type of things also. That's what it should be, that you have the right to seek counterclaims, any claims you have against them. There's nothing on the record saying that in those other cases that Mr. Basile wasn't the landlessor on the rental agreement. I must make this point with regards to these specific two cases. In the Williams case, with Mr. Heisler, he puts in his brief the conduct leading up to the violation being the signing and filing of the complaint. He talks about that the rent with the housing authority, okay, was $1,000, and that the landlord was charging $300 over what Section 8 allows, And that's the conduct leading up to what became the notice in the complaint. That was the actions of the landlord. That wasn't Mrs. Basile. There was no actions by Mr. Basile leading up to the signing and filing of the complaint. And Claremont said that's what needs to happen. And nothing happened after that.
How about not being able to bring a counterclaim because of that? So Williams says that there's a side rent being charged beyond the Section 8. Mm-hmm. And Hatcher, I think, is saying that the notice to quit was filed before the tenancy terminated. The notice to quit wasn't on Hatcher, was not a failure to pay rent. So it had a different notice to quit period. And so as it relates to those legal issues in both cases, how come it's not a harm that you can't bring the counterclaim, at least as it relates to Williams?
Bring which counterclaim? Maybe.
Well, there's a counterclaim going on for, as it relates to charging a rent that wasn't owed.
They brought counterclaims for those things, Your Honor.
But they couldn't have pursued them at that point in time because Basile couldn't have defended them.
But everyone was added in as additional parties. There was an amendment to the complaint and so forth. Mr. Basile and the owners were eventually all joined up.
No, I understand. Well, it's a much simpler point. Going back to Justice Kafker's point about if you have to go to court, you're harmed. And there's a point to be made that, well, there would have been a notice to quit anyway in both of these cases.
Yes.
And so where's the harm? And then when the defendants, the appellants, were addressed in the court, they said, well, part of the harm is there might be counterclaims and they couldn't be brought.
I don't believe that's true. They were allowed to bring, they amended their complaint for all the counterclaims that we're talking about. That was always amended. The other part that you must know, okay, and it's part of the record appendix, okay, I believe 101 is our memorandum in opposition to the motion for summary judgment. But at 120 and 122 is an exhibit of a settlement agreement. The same day that I filed my appearance in the Hasher case, and we went to case management, Attorney Feldman filed a settlement agreement with the owner. In which the tenant got it was $9,000. The tenant got $3,500, and at that point in time, Attorney Feldman had filed an appearance, boilerplate answer and counterclaim for his office, boilerplate discovery request, and it hadn't been done, and Mr. Feldman got $5,500. So who's unfair? Who's gaming the system? That's what we're trying to say, that they talk about was what Mrs. Basile's doing.
Can you tell me, do you think, I know you don't think your client committed a 93A violation. What is permissible for your client to do now under LAS? Can your client file a complaint, or do you recognize that's inappropriate? I mean, can your client file a complaint and then as soon as there's a motion for trial drop out? What can your client do now?
That is what I was trying to make a point in your LAS decision. There's 2 footnotes.
I understand that you don't believe there's been a 93A violation. I also believe that you say that we lumped together 3 different requirements. You can't file a complaint, you can't litigate, you can't blanket anybody. What is your understanding of what's legal for your client in his business to do now? What can he do?
Based upon Judge Fine's decision.
Forget about Judge Fine. What do you think is legal under our case law for your client to do in terms of moving these cases? Anything, nothing, everything he did? I'm just trying to understand now.
As you stated from the beginning, his actions, okay, if you take everything out of the picture, would violate LAS, okay? However, in the footnote in LAS, you said a couple of things, that no one appeared for LAS, and no one was briefed, so we have to narrow what issues in front of us. No one appeared or filed a brief LAS, so no alternatives were given as what a property manager can't do and can do. You also noted in Florida.
I know, but I'm asking a very simple question.
Yes.
What can he do? Can he not do none of this? I understand it's not a 93A violation, your view, but is it your understanding that he can't do any of these activities? Meaning he can't file a complaint because he's not the landlord or the owner. He can't appear as the sole representative of the landlord or owner. I'm just trying to understand what your understanding of what he can or can't do right now.
Absent a ruling by this court, he can't do any of that.
Okay, I understand, but all right, I'll drop the question. Don't worry.
Absent a ruling of that.
I have one more question, Chief. All right, so you're saying there has to be something more than the unauthorized practice of law to have a 93A violation, correct?
Yes, sir.
And how do you distinguish the Zero case, where an eviction, at least the position of the appellants is an eviction, improper eviction would be a 93A case?
Well, if you take that train of thought, anytime there would be, anybody would bring an improper eviction or a defective eviction, they could be susceptible to
Yes,
93.
I'm asking about Zero versus Federal Home Loan Mortgage
Oh,
Corporation.
Sierra.
Yes.
Okay, Sierra, that was the conduct, getting back to the conduct. They said that the home loans, the reason they said that with the summary process complaint, because they were dealing with the sale of the property. It was about the sale of the property, not a straight eviction. Okay. So because the sale of the property came into the case, that's why that happened in that particular case. That's differentiated. That's not what they state, the appellant. They said it can be dismissed and it could be a 93A violation. But it was the sale of the property that was behind all that ruling, Your Honor.
All right, I understand. Thank you.
All right, thank you. And we'll take our morning break.
All rise.